Thank you for that introduction, and good afternoon. Thanks for having me speak to you. As our chairman has said, I'm from an organisation known by the acronym AVMA. Probably few of you know the organisation well, but it stands for Action Against Medical Accidents. And I should perhaps start by explaining a bit more about what we do and why this gives us a perspective on the subjects I've been asked to speak to you about today. We're actually celebrating our 30th anniversary this year. We've been around that long. And we have two main roles, two main aims, and that's promoting better patient safety and promoting justice in the wider sense, and in particular for those people whose lives are affected, often devastated, by avoidable medical accidents. We have been very pleased that notable people such as Sir Liam Donaldson have accorded us a lot of the credit for getting patient safety on the map. I think it's fairer to say that it's those patients who've suffered medical accidents over the years who deserve most of the credit, and the doctors and other health professionals who've shown passion and commitment for getting recognition of this. But we have played our part. When we started, patient safety wasn't recognised as an issue, nor was the problems, the very severe problems people have in accessing justice when something goes wrong, properly understood. At the heart of the charity's work is, as well as trying to influence policy and practice, to provide a direct, independent and specialist advice and support service to people who have been, or fear they have been, adversely affected by things going wrong in healthcare, by medical accidents. That's done chiefly through a helpline, a national helpline that's available all around the UK. It's staffed by specialist medico-legal advisors, and in a certain number of cases we also do quite detailed casework where we'll go through medical records, we'll go through complaints and other types of investigation reports to help the patient or their family get to grips with exactly what's happened, to understand what's being said to them, and to understand what their rights are. Now, often that involves complaints. It also will sometimes involve litigation. And we make no apologies for the fact that where people need and deserve compensation, we will advise them of that. We will put them in contact with genuinely specialist lawyers who we ourselves vet and accredit as having both the specialism and the integrity to provide a good service to our clients. But far from it being all about litigation, only about 10% or less of the people who come to us each year go anywhere near a lawyer. Most of them don't want to, or it's not appropriate for them to. And that's, to give you an idea of the scale of our work, we deal with 3,000 cases a year. And we put great emphasis in working in partnership. We work not against, but alongside the NHS, Department of Health, health professionals themselves to try and get better awareness of patient safety issues and get improvements in patient safety itself. Those of you in the audience who do know of us probably know of us because of your work in medico-legal work. One of the things we do to support lawyers who support our clients is maintain a database of medical experts who are prepared to give objective, independent reports in medico-legal cases. Okay, so that's a bit of background. I'd sum it up, however, by our simple slogan. We stand for, and we're passionate about, patient safety and justice. I think this is important because a lot of people try and separate out these two things. People will talk passionately about patient safety and say that justice has got nothing to do with patient safety. We think that they're integral to each other. They go hand in glove. To put patient safety in context for us, let's just look at two very different statements in terms of when they were made. As to diseases, make a habit of two things: to help or at least do no harm, Hippocrates, and much later. Medicine used to be simple, ineffective, and relatively safe. It is now complex, effective, and potentially dangerous. Of course, we have to realize with all the advances, with the incredible work that you and your colleagues do, also come increased risks. In terms of the scale of the problem, these figures are not our own. They are official estimates by the Department of Health. I'm sure you're familiar with them. They're taken from a small number of retrospective case note reviews, but are widely accepted, and they're consistent with international research into the occurrence of adverse events, patient safety incidents. At least 1 million patient safety incidents a year in English hospitals alone, it's estimated. That figure is probably higher using the same calculation because it was based on 10% of hospital inpatient admissions. 50% of these resulting in harm, half of which are avoidable. That makes for about 250,000 medical accidents actually causing harm and potentially tens of thousands of deaths. Of course, no one actually knows the real figures. We're still playing catch-up in terms of identifying, reporting and recording the scale of patient safety incidents. There is now, of course, the National Patient Safety Agency's National Reporting and Learning Service. And from its most recent report, I've extracted this. Now, bear in mind, these are actual reports that have been received. Other research, including that published by doctors.net, suggests that only 10% of incidents actually get reported. So these are the ones that actually got reported. And for this period, 1.2 million patient safety incidents were reported. 84,500 of them related to moderate to severe harm to the patient or even death, and 2,851 specifically identified death as the outcome. You can access that data yourself. Clearly, if it's true that only 10% or a minority of patient safety incidents are reported, these figures become even more alarming and scary. Let's compare them to some other disasters. Road traffic accidents have a very large part in our consciousness. The latest ONS data for 2010 records 1,800 of those causing death. The largest passenger aircraft, the A380 Airbus, carries up to 850 passengers. So you don't need to be a mathematician to see that each year the NHS, or healthcare, is seeing the equivalent of numerous crashes of the Airbus A380 with 850 passengers in each. The Marchioness disaster, which had such an effect on us all, the Clapham Rail disaster, we're talking about 51 deaths, 35 deaths. One of the biggest pieces of work that my charity has been involved in recent time is being a core participant and giving evidence to the Mid-Staffordshire NHS Trust public inquiry. In that trust alone, during the period of the inquiry, we're potentially looking at hundreds of avoidable deaths. The financial costs, well, again, it's estimated that at least £1 billion is spent on remedial treatment, on extended hospital stays for people as a result of medical accidents, of avoidable medical accidents. That's not counting, incidentally, hospital-acquired infections. If you add hospital-acquired infections to the scenario, we're talking about at least £2 billion. Now, litigation is often cited as one of the things that is bleeding the NHS dry. In the most recent figures published by the NHS Litigation Authority, which just covers England, 863 million was paid out on clinical negligence claims. That's not all damages. It also includes the legal fees of both the defence and the claimant lawyers. It is one hell of a lot of money. But let's keep this in context. We're talking about a fraction of the overall costs, and we're also talking about a, thankfully, state indemnity situation with the NHS, whereas in most high-risk industries, the insurance premiums alone would probably overshadow the amount that's actually being paid out on those claims. But I'd also like to say that from a charity's point of view, the other costs and implications are much, much greater. Litigation for years in medicine has been the elephant in the room. It's used as an excuse in many cases for not having an open and transparent culture. It's fitted neatly into what people liked to describe the blame culture. Is there a litigation culture when it comes to healthcare? The tabloid newspapers would want to have us believe so. The facts absolutely deny that. If we take the figure of 1.2 million reported patient safety incidents, the 84,000 cases causing severe harm or death that are actually reported, and then compare that to the number of claims received by the NHS Litigation Authority, that was only 8,655. So it is absolutely crystal clear that only a tiny fraction of those people who might well have a viable clinical negligence claim, should they be aware of all the facts and all the circumstances, actually make a claim. And I can tell you now that our years of experience of advising people on the helpline and in our casework service clearly demonstrates that people will go to extraordinary lengths not to get involved in litigation, not to sue a health professional or the NHS. Rather than there being a litigation culture in healthcare, I would argue there's actually an anti-litigation culture. People, even when they have been damaged by negligence, are still reluctant to seek legal advice, to take litigation further. It's frowned upon by friends, by family, and we still, thankfully, hold the health professions and the NHS in such high esteem that, as I say, people will do anything to avoid litigation in many cases. Of course, in some cases, people need that compensation, and at the moment, it's the only game in town. If you have to bring up a child who's brain damaged, for example, for the rest of their lives, you both deserve and need that financial help. I suspect where there'd be quite a lot of agreement is that there should be a better way. Litigation and the adversarial legal system is not a friend of patients and families any more than it is health professionals. For years, there's been discussion about alternative approaches, no-fault compensation schemes, administrative schemes that actually avoid the need to involve lawyers so much. We've greatly welcomed and called for these initiatives, but unfortunately each time they've been looked at the end, people haven't had the commitment to see them through. Various reasons are given for that, but I think one of the real reasons is that litigation is so difficult for the ordinary person to pursue, again, contrary to what the tabloids would have us believe, that itself acts as a filter, and even deserving cases increasingly find it difficult to get the resources and the evidence necessary to actually see a deserving claim through to fruition. Fortunately, with expert help and advice, some people do. And as I say, the implications about all of this for us extend far beyond money. It's about real people and real lives. These are two cases which aren't surgical cases, I'm afraid. They both happen to be obstetric cases where Martin here on the left and Holly on the right both have cerebral palsy as a result of errors in healthcare. Now, obviously, that has been a devastating thing for them and their families. It means they haven't been able to fulfill their full potential and never will. But thanks to their own and their families' heroic efforts, but helped with the financial compensation that the families have managed to get, actually they have done remarkably well in the circumstances. So, in terms of human costs, which are the really most important thing in all of this, as well as the obvious lack of mobility, the disability and the death that arises, we should also take into consideration the actual emotional and psychological effect on people affected by things going wrong, the shock, bewilderment, anger, not just at those people who allowed the mistake to happen, but with themselves. The most common emotion, again, we come across, particularly when we're speaking to parents over a child's case, is anger that they somehow didn't challenge the hospital, didn't challenge the health professionals over the care of a loved one, be it a child or an older relative. Profound loss, fear for the future, wondering how you're going to cope, and also loss of trust in the NHS and in the health profession, profound psychological costs. But as a charity working in this area, we're also profoundly aware of there being a second victim, or several secondary victims, in the form of the health professionals caught up in what is usually, we believe, a system failure. It's rarely down to culpability of an individual. And unfortunately, that's where clinical negligence litigation drives the whole concentration of the inquiry. Can we pin this on the individual negligence of one or more individuals? That's the way the system works. If we had a system that looked at more broadly at should the healthcare team, should the health institution have avoided this incident, we'd have a much fairer system and one much more geared to learning lessons. But the effects, the human effects on those caught up in this, I'm sure will be very well known to you, if not from you personally, through colleagues, the loss of confidence, the sense of shame, people actually leaving medicine as a result. I put a query here, defensive medicine. That's for another debate. I don't quite accept most people's perceptions of defensive medicine if being defensive means going the extra yard to save, to safeguard your patient. And of course, at the ultimate extreme, we know that people have committed suicide and become extremely depressed. Why is there this stigma? Why is there a sense of shame? To err is human, goes the phrase. We all accept that anybody can make a mistake. And I don't mind telling you an absolutely true perspective of my own, having worked in this field for many years, is that I would far rather be treated by a surgeon who has made a mistake and has gained better insight and become a better professional as a result of having made a mistake than a surgeon who thinks that he or she is incapable of making a mistake. I think people can go on and be even better professionals by learning. Now, things have moved a lot since the early days of our charity being formed. As I say, some people have very graciously given us some of the credit for that. So things that we were calling for, such as the establishment of a national patient safety agency to actually record data on what is actually happening, what is going wrong, and make that available to the service, was created. That's in the form of the National Reporting and Learning System I referred to earlier. On the basis of what's going wrong, they issue patient safety alerts. One of them, of course, being the famous safer surgery checklist, but there are many others on issues that, not routinely, but that go wrong far too often. that are known to go wrong, but about which there are known safeguards and solutions which will greatly reduce the risk of them happening. We have the initiative of never events over the most easily avoidable issues that go wrong. And we think this is crucial as well, we have a regulator. That's now in the form of the Care Quality Commission, the CQC, a body which has come under intense scrutiny, will be under scrutiny in the findings of the Stafford report, I assure you as well. It's far from perfect, but we think it's very important there is a national regulator that seeks to monitor and actually regulate standards in our healthcare service in a way that there simply wasn't before. It simply needs to up its game. But what is happening now? Well, in our perspective, having made all those advances and at least having got patient safety to the top of the agenda, our perception is that patient safety is now dropping down the agenda. It seems to be being subsumed into ideological notions of quality and commissioning and even competition. The rather simplistic notions that if something is commissioned, quality will necessarily be paramount in that commissioning process, and as a result, safety will be improved. The notion that if there's more competition, that inevitably will drive up safety and quality. I haven't seen the evidence base for that. I don't know if you have. Having got the National Patient Safety Agency established, and it, again, far from being perfect, but at least having started to do some very important work, we're now seeing it abolished. Its work, in as much as it does carry on, will simply be subsumed into the NHS Commissioning Board, but surprise, surprise, with a tiny fraction of the resource that was made available to the NPSA. On the justice side of things, you may have heard and read that there's been a very controversial piece of legislation going through at the very same time as the health bill. We were lobbying madly over something called the Legal Aid Sentencing and Punishment of Offenders Bill. And at the core of that was the abolition of legal aid for most of the most vulnerable people who our charity has to try to help, and who are the victims referred to in the context of this discussion. Absolutely incredible that the most vulnerable people, those least able to afford going to a solicitor, paying for insurance, paying for medical expert reports, are no longer going to be able to access legal aid, even to get an investigation, even to get to a point where perhaps it's concluded that there isn't a clinical negligence case. I believe that's going to have profound implications for all of us, because when people see access to justice being closed down, it fuels a more adversarial approach. If people feel that they're being unfairly denied access to justice, then they will take other measures, such as making complaints, referrals to the GMC, and so forth. So, again, working against what we all favour, which is more of a fair blame culture, as opposed to an inappropriate blame culture. One of our main campaigns over the years has been for a duty of candour, something that Chief Medical Officer Sir Liam Donaldson has also called for, as many other clinicians and patient safety experts have. We called the campaign Robbie's Law in order of a particular case that we've been involved in for years. It remains the case, however, that whilst we've made some progress and the government has said it's going to bring in a so-called contractual duty of candour, there is no statutory requirement in this country to be honest with patients or the families of patients when a medical accident has occurred. It's in your good medical practice guidance, but in our experience, for example, at Stafford, where there were some absolutely gross cover-ups, it's often not the clinician, not the doctor or the nurse who wants to cover up an incident. it is either the management or the people who are giving legal advice, who say nothing, keep stum, let's see if they make a claim, we'll play it absolutely by the rules, don't do anything we don't have to. I think that's one of the most worrying and scandalous things about our health service, that even in this day and age, we haven't been clear enough to say there is no other option, you must do the right thing, you must report incidents and make the information fully available to patients and their families. And of course, together with this very, very worrying mix of circumstances, we've got the reformation of the NHS, the fragmentation. And it seems to stand to reason to me that the more complicated you make the system, the more fragmented you make it, the more risk you introduce. And of course, there's changes to training, which surgeons and other doctors have told me have very grave implications for patient safety going into the future. I want to leave it at that, but before I do, I just wanted to draw your attention to something which I hope that every one of you would be able to sign up to. It's something we developed with doctors to help mutual understanding about some of the issues I've just had the time to touch upon and which other speakers will talk about today. This Charter of Understanding, which has been signed up to by most organisations, sets out half a dozen simple principles which we can all share. The need to educate patients and the public about risk. That if something does go wrong and there's a dispute, treatment shouldn't be affected. That doctors are only human at the end of the day, and that they themselves need support and understanding to become even better health professionals, hopefully, in very difficult circumstances. Fundamental one as far as patients are concerned, and I think medical ethics is concerned, we must not dodge this question any longer. We must have an absolutely robust statutory requirement to inform patients and their families when things go wrong and take action about those who do not follow that. And people, quite rightly, should get compensation and other forms of redress if things go wrong. As I say, at the end of the day, it's about real people and real lives, but that includes each and every one of you. Thank you very much. I look forward to your questions and comments later.